Hello dear viewers, now today I am going to give you a training on Bangladesh Labour Act 2006 and Bangladesh Labour Rule 2015. Okay. Labour Law Reform Commission. Okay, a commission was formed in 1992 and it was headed by Justice Abdul Quddus Chaudhary. It was 38 members committee, and after working 2 years, the committee generated a report of 815 pages. The report was submitted to government in 1994, and after 10 years, the government started working on Labour Act. Finally, in 2006, a Labour Act has been passed in the Parliament as the then Minister brought a public bill in the Parliament on 11th October 2006. The 8 fundamental conventions of ILO. Number 1, Forced Labour Convention 1930, it is number 29. Number 2, Freedom of Association and Protection of the Right to Organize Convention 1948, number 87. Right to Organize and Collective Bargaining Convention 1949, it remains in the report of 98. Equal Remuneration Convention 1951. Abolition of Forced Labour Convention 1957, Discrimination, Employment and Occupation Convention 1958. Then Minimum Age Convention 1973. It is the point number 138 in the report. Worst Forms of Child Labour Convention 1999. Then comes Convention rectified by Bangladesh. 35 conventions are ratified by Bangladesh. They are Fundamental Convention 7 of 8, Governments Convention 2 of 4, Technical Conventions 26 of 177. 33 are in force. 2 conventions have been denounced. Implementation Authority of Bangladesh Labour Act and Rules. Okay, now I'm going to. How many labor courts are there in Bangladesh? Dhaka 1st Labor Court, Dhaka 2nd Labor Court, Dhaka 3rd Labor Court, Chattogram 1st Labor Court, Chattogram 2nd Labor Court, Khulna Labor Court, Borishal Labor Court, Rajshahi Labor Court, Sylhet Labor Court and Rangpur Labor Court. Okay, now Central Fund, Workers' Welfare Funds. Now comes the outline of the Act. In this Act, we can find general condition of employment in Chapter 2, 3, 16A and 18. Compensation and benefit we can find in Chapter 4, 8, 9, 10, 11, 12, 15 and 17. Industrial relation we can find in Chapter 13 and 14. Health and safety we can find in Chapter 5, 6 and 7. Administration and miscellaneous we can find in Chapter 19, 20 and 21. Okay, in this Bangladesh Labour Act and Rules, total 355 sections, 367 rules, total 132 forms of employers and government. Okay, 5 times these rules were amended. In first amendment, 8 amendments were made in 2009, 3 amendments made in 2010, 87 amendments in 2013, and 41 amendments in 2018. Now comes the main part of this lecture. Who is a worker? Worker means any person, including an apprentice, employed in an establishment or industry, either directly or through a contractor. By whatever the name he is called, to do any skilled, unskilled, manual, technical, trade, promotional, or clerical work for higher reward. Whether the terms of employment are expressed in or implied, but does not include a person employed mainly in a managerial, administrative, or supervisory capacity. Supervising officer, person authorized by the owner or the managing authority in writing, determines the target of any work and service, controls the extent of the work, implementation activities, assesses or reviews of the work, and direct or supervises the work of any section of the factory or firm. Administrative or managerial work, person authorized by the owner or the managing authority in writing, appoints workers or employees, determines the salaries and allowances, terminates the services or removes from the service, pays off the financial dues, and approves or controls the expenditures of the firm. Which organizations under the Labor Act and rule? Save as otherwise specified elsewhere in this Act, it extends to the whole of Bangladesh. Application of Chapter 2, any shop or industrial or commercial establishment owned and directly operated by the government where the workers are governed by the conduct rules applicable to the government servants. Any worker, those recruitment and terms and conditions of service are governed by the acts of the rules made under the Article 62, 79, 113 or 123 of the Constitution, but in the case of application of chapters 12, 13 and 14, the workers employed in the following establishment shall not be subject to the provisions. Okay, thank you. We will see in the next part.